in respect of all the accused except accused 12, if I'm correct. Some of them as late as this morning, but at least we received it.
Yes. But I seem to recall Mr. Mazibuko saying that he's not going to file any, and therefore the deeming provision can kick in with regard to accused number 12. So meaning therefore that they admit everything that you have that is factual in the 212B that you served on them.
Yes,
so there's no need for them to file any.
100%.
Good.
That's the plea.
Mr. Otis, I think there were two outstanding issues. The one pertaining to the list of witnesses implicating your client, accused number 13, as well as your Section 85 notice.
Yes.
And has that been resolved or is it still outstanding?
Yes.
Mr. Donation.
As it pleases the court. I'd like guidance from the Honourable Court whether the Section 85 objection should be addressed beforehand or by the court presiding.
Well, it should be done before plea. Which court does it is neither here nor there. If you prefer and that the matter be dealt with prior to that, it's no problem. And it will also depend what are they challenging with regard to your charge sheet.
Yes, it is basically
because
that Section 34 isn't applicable on accused 13. That's the basis of it.
And has there been a request for further particulars as to why you allege that accused 13 should be charged?
There was no request for further particulars. The only request for further particulars that I received was in behalf of accused 16.
Yes, no, we'll deal with accused 16. Yes.
But I just need guidance from the court whether it should be addressed by a different presiding judge or at the time of the trial, before plea.
Yes, Mr. Donation, look, firstly, all the other accused are not involved in that application. It will only be accused number 13. So logistically it's a question of whether all the other accused must come to court only to listen to the application of accused number 13. And I think it would actually be better if that is done separately and judgment in that matter given before the commencement of the trial, obviously, because it cannot be done after plea.
As it pleases the court, I shall then, as soon as possible, file my response thereto.
Okay.
But pertaining to the, sorry, Bill.
Yes, continue.
Pertaining to the list of witnesses directly implicating accused 13, the state declined. Pertaining to those two issues. As it
Yes, thank you, Mr. Otis.
My Lord, focusing on accused number 13 for the moment.
Yeah.
Accused number 13 also, in an associated objection, my Lord, notified the state that they hadn't complied with Section 27 of the Act, which required certification prior to the institution of those proceedings in terms of popery, my Lord. So we have given them two notices. One was after the other, but they are both related. So accused number 13, my Lord, takes the point, and the Lordship will remember from the first pre-trial meeting, we said that there is a debate concerning the status of Mr. Lotza.
Yes.
The state contends that she's a state witness. We say that she was a defense witness before. We had a signed statement for her. My attorney, Mr. Nkwashu, Victor Nkwashu from DNA Inc., have attended at the State Capture Commission on her behalf and represents accused number 13. And they were both involved at the same time, instructing the same attorney. And we recorded that when we received the docket, it was clear that her statement had not been signed, even though they claimed during the bail application that she was a state witness and we were not entitled to communicate with her. That is another issue, my Lord, with respect that I submit must be resolved before the plea stage, premised on the principle, my Lord, that the accused is entitled to know the case that he has to meet in terms of Section 35 of the Constitution. That's accused number 13, my Lord. I act together with Mr. Neil Governor as my junior as well on behalf of accused 3 and 4 as well, my Lord. Accused 3 and 4 took a more fundamental objection to the trial, my Lord, and that was premised on accused number 3 having been compelled to testify at the State Capture Commission in front of the then Deputy Chief Justice Londo. We recorded in advance, my Lord, that all questions would be answered truthfully and that he cannot thereafter be prosecuted premised on the answers that he gave. My Lord, the objection is based on, in summary, my Lord, is based upon the docket having been opened subsequent thereto, as we have revealed after we brought an application to the High Court here, my Lord, for the B and C sections of the docket, the second diary, which then strengthened our suspicions and confirmed that in our submission, I know that my opponent disputes this.
Yes.
We say the whole docket arises from that commission, and we say that having been compelled to answer under threat of even being incarcerated if he didn't, accused number 3, who then represented accused number 4 as well, with respect ought not to be tried. It would be unconstitutional to try him. Now we believe, my Lord, that these issues need to be resolved before the plea stage. I am in a similar position to Mr. Donation in this regard, my Lord, in that we need to formulate or agree on a way forward. In other words, my Lord, by when formal documents must be filed, such as a notice of motion encompassing the objection on behalf of accused 3 and 4, and I believe the same would apply to accused number 13 and whoever else might be taking preliminary objections, my Lord.
Yes,
and then giving the state an opportunity to answer and then to file a reply and then to put the matter down for trial. I'm in respectful agreement and record with the Lordship that the necessity to have all the accused here, only those that are bringing such points or intent, and if it's only 3, 4 and 4 and 13, so be it, my Lord. I don't have
Yes,
an issue.
no, I think accused number 16 is taking a similar point with regard to Section 27 of the Act,
Yes,
as well as other further particulars, but I'll hear from Mr. Donation when it comes to accused number 16.
That's why, my Lord, coming to your Lordship's function, but just as a suggestion, my Lord, and aligned to what Mr. Donation said, I thought it would be opportune now to set some time limits and dates so that you can work towards these, my Lord, to have these preliminary issues finalized, and whether your Lordship presides or the trial judge, if there are issues that ought to be taken prior to the plea stage, my Lord, I'm not looking at a Section 106 special plea or anything like that. These are preliminary issues that go to the fairness of the trial, my Lord, and I respectfully submit ought to be resolved before we go to the plea stage.
Yes, just with regard to the objection with regard to accused number 3 and 4 and their testimony at the State Capture Commission, so-called State Capture Commission, is that an issue that should be dealt with prior to plea, or is it an issue that should be objected to during the trial when certain evidence is about to be used against them?
My submission has always been that it ought to be resolved before, and I'll explain why I make the submission. My Lord, the entire indictment is premised upon the facts that were the subject matter of the State Capture Commission in relation to accused 3 and 4.
And nothing extraneous to that?
No. we can speak very openly on what relates to the asbestos audit and how his company went to, that's accused number 4, entered into a joint venture with the former accused but now deceased company, and the joint venture was formed, and how they then, the allegations were as to how the contract was then secured by that joint venture, which is then the subject matter of the charges against accused 3 and 4. That's it, my lord.
Okay. All right.
So I submit, my lord, the entire basis of the charging. That's always been our argument. I understand the nation has a different view, my lord, but I would submit that we need to resolve this up front, my lord, because it goes to the fairness of the trial, and we don't want to start a trial with 23 odd, I might be incorrect on the number accused, start with what would then be considered an interlocutory application to determine the fairness of the trial while everybody's waiting in abeyance. I believe, with respect, my lord, it should be resolved up front, where a court makes a decision this person can be tried against having testified before the Zondo Commission, or cannot be testified, and the other trial can continue within his absence, because there are other allegations, but not in relation to accused 3 and 4, in my respect for submission.
Yes, I think when all the papers are filed with regard to all the objections, this particular objection can then be dealt with. We'll cross that bridge when we get there. Okay, thank you.
My lord, it might just be appropriate to record at this stage that accused 1 also intend to bring a similar application than accused 3 and 4 relating to the State Capture Commission.
And the objection is also based on the fact that the entire case against him is premised on the evidence at or testimony at the State Capture Commission.
Exactly the same, my lord.
Yes, Mr. Delason, before we deal with accused number 16's objections, there was a request for further particulars by accused number 16. I see it was only delivered yesterday.
Correct.
If memory serves me, yeah. So, what is the state's position with regard thereto? Have you answered to it, or,
Yes.
or not yet?
The state is compelled to answer in terms of section 87, so
Yes.
yes, I'll do that. I just need time to study.
Time.
They,
But it's only premised on the common purpose allegation, as far as the further particulars is concerned. And then there's a separate and distinct objection, which deals with section 27, whether they were indeed given an opportunity to render an explanation. Yeah. So,
there's also a voluminous document pertaining to representations delivered at our office. But
oh,
that's now a side issue, but
okay.
I also received that,
That, okay.
which we also have to consider, of course.
All right. So the issue of the further particulars then is a non-issue. It's only a question of time.
I should
Right.
address that.
Good. And then they say that, or the allegation at this stage is that the state does not have the wherewithal to charge them, because in terms of the act, they were supposed to get some time in order to give an explanation. And in terms of the act, they may not be prosecuted if that has not been done. That is their argument. Now, has that been done? Because that is an objective thing. It's either they were asked or they were not asked.
My Lord, we did not want to broadcast the intention to arrest certain people. The main charge, the one of fraud, the accused would in any event have been arrested for fraud. The contravention of section 24 is only an alternative. If the accused are so adamant to give some other reason, they can still do that.
No, Mr. Davidson. Please. I think section 27 is clear. It says that if you want to institute a prosecution in terms of section 34 sub 2, there must be firstly authorization in writing. Now they're asking you, do you have authorization in writing? And if so, favor us with a copy thereof. You can't just say, well, it's an alternative charge. The fact of the matter is it is a charge. And then secondly, they say, in terms of the act, they were supposed to be afforded an opportunity to explain, and they were never asked to. So you can't say it's an alternative charge and therefore there's no need to ask them that.
My Lord, I shall file proper and comprehensive papers in this regard. Because it is a formal application, I need time to file proper and comprehensive answer to those allegations.
No, Mr. Dennison. As I understand the Act, maybe my understanding of it is wrong. It says before you institute the prosecution against them, you must have authorization in writing. So therefore, the step of instituting the prosecution against them, whether by way of an alternative charge or by way of a main count, should be preceded by a written authorization. And they are saying, well, now that we are here, we are charged with this, or especially accused number 6, although his legal representative puts it much wider. He says, well, now that I am here, I am charged with contravening this section, but I have not been favored with a copy of the written authorization. And if there's no written authorization, there cannot be any charge. That is how I understand. Now, it's either you have the authorization or you don't.
I have the authorization. I understand that the main problem is the fact that they weren't offered an opportunity to give some other reason.
No, they say there was non-compliance with section 27 of the Act. So, in order to comply with section 27, there must be written authorization, and they actually request that in so many words. I think accused number 16, where is it? Yes, paragraph 2 of the notice, accused number 16 states the following. The state is requested to supply the defense with copies of each and every request, whether by letter, email, or telephonically, done in which any of the accused prosecuted for the contravention of section 342 of Act 12 of 2004 was or were invited, afforded a reasonable opportunity to explain why they did not report in terms of the provisions of section 342. The state is requested to supply the defense with a copy of each and every letter directed to either the National Director of Public Prosecutions, any Deputy National Director, or the Director of Public Prosecutions Free State, seeking a written authority in terms of section 27. That's what they're asking. So it's on both legs that they are saying the state has a problem instituting the prosecution against accused number 6 at this stage, although his attorney says any of the accused. But I think we can limit it to...
And I say again, this document was signed on the 29th of October. I received it yesterday. I need time to prepare documents, my reply to all of this, which I shall do.
But that's what is it a reply or just to supply the documents? Because all that accused number 16 wants at this stage is a letter or email confirming that you have been given authorization to prosecute him. And secondly, whether he was given an opportunity and whether there is any letter stating that he's afforded the opportunity to state his case before the institute, before charging him of the crime. Now, that can't take so long, Mr. Donation. If you have it, give it to them. Why? Yes, by when will you give it to them? Because we can't work on you saying, well, you must prepare documents. If you have the documents, just give those who are charged with contravening Section 34 of POCA. Let's get this trial underway.
I shall do
So, at this stage, it is only accused numbers 1, 3, 4, and 13 that have objections that need to be dealt with prior to plea.
And I think 16.
What? No, 16 is it's not something that it's just for you to hand over the documents. Because if you have them, you just hand them over. There's no need then for a formal process. And if you don't have them, then obviously you can't institute the proceedings against them. Okay, good. Now, yes?
Then the issue pertaining to on what this case is based on, I'm not going to repeat myself, but suffice to say, as previously, the testimony during the Zombie Commission is a nice to have. But that is an admissibility question. Admissibility of evidence, in my view, it cannot be decided or adjudicated before the trial starts.
Yes.
I think it should be addressed in a trial, within a trial of some form, during the trial.
Seeing that Mr. Houders is inclined to lodge a formal objection to the prosecution, I think that can come through in your answer to his founding affidavit.
As it is.
And whatever, if they are so minded to reply, let them reply, and the presiding judge will then make the judgment call whether it is something that ought to be dealt with during the trial or at that stage.
Indeed.
Yeah. So what I would require now is firstly for the parties to indicate whether, bar all these issues canvassed now, the matter is ready for trial. And if so, then we should look at trial dates, and only thereafter will I be able to give a map, a roadmap as to how we are going to deal with the other preliminary issues.
As it is.
So, yeah.
There,
Mhm.
there is also the issue of Magashule, which is apparently a thorn of contention, a thorn in the side of especially accused number 13.
Mhm.
We have sent the detectives to the USA some time back. They came back and they reported to us that, in a nutshell, Magashule is not cooperating. She is therefore not deemed to be a witness for the state anymore. In the circumstances, I had no choice but to sign a warrant of arrest for her, and we are now busy with the process to get her back in South Africa. So that is the position. She is a suspect, soon to be an accused in this matter. I shall add her as the moment she gets into South Africa. If there's some other kind of hiccup and we can't get her here timeously, then the state will have no choice but to proceed without her. But that is the position pertaining to this.
Okay.
She left us with no choice, unfortunately, and that is the position.
All right. So, Mr. Houders, the issue of Ms. Charlotta is then a dead letter. It's not something that you pursue further if they are going to charge her with the other accused. Because then the issue of whether she is a state witness or defense witness does not arise. She will then be an accused person.
No, my lord, with respect,
Yeah.
it's more serious than that. During the bail application on the 13th of November 2020, we were informed of the fact, matter of record, my lord, that Ms. Charlotte is a state witness, we may not communicate with her. That could not have been the truth at the time it was just in the light of what we just heard now. It shows also, my lord, that the state then, if the charges, as was contended then, were premised on the evidence given by Mr. Lotte, are clearly not ready for trial. I don't know how my linesman tells your lordship, we're in a process, we're going to arrest somebody, extradite her here and charge her, but we're ready to go to trial in any event. So you've got now a person who has moved from being a definite state witness to a suspect because of a non-cooperation to yet we're ready to go to trial. They're mutually exclusive of one another with respect, my lord. And
why do you say so, Mr. Otis?
because, my lord, either she was a witness or she wasn't. It's quite clear now that she wasn't.
No, they say she was a witness. That is why they sent the detectives to the United States of America, and they could not get a statement. You remember on the last occasion, or the last but one, you informed me that you have, or Mr. Victor Kwashu, has an affidavit by the witness or the person. The state prepared a statement which he did not sign. And that is basically all that we had about this witness. Now, the nation is saying, well, we're jettisoning the witness. We're not going to call her anymore. But what we are going to do is we are now going to cause her to be arrested and to be added as an accused in this matter. So why do you say that matter is still a live matter? If you are saying, well, the state was dishonest in the bail application, but that does not change the situation that she'll be an accused person. And therefore, the statement that you have, or the affidavit that you have, and the statement that they have, can be used against her or not be used against her, but that's a matter for the trial court to then decide, not so. How is that still something that must be entertained by way of an objection? Is if the state says she is no longer a state witness, we are not going to call her anymore. As a matter of fact, we want to have her arrested.
My lord, if I may just trace the background and explanation in all this stuff. The first time that I, my attorney, or our clients heard that Ms. Charlotte is no longer a state witness is now, before
Yeah.
your lordship. We never heard it.
But you haven't heard it before.
No,
Okay.
my lord. So that with respect needs to be put out there and recorded as a fact.
Well, it is put out there.
Yes.
It is on record. Mr. The nation is now on record. It says we're jettisoning the witness.
Yes, my lord. But, as your lordship summed up, if they were dishonest in the bail application, and I hadn't put it as strongly as your lordship did, it's a factor to be taken into account because they stated, and it's recorded, my lord, she is a state witness. Not she may become a state witness or she's a potential state witness. We were told she is a material state witness and will be used to testify against him, so he may not communicate with her. That was a misstatement. And the only way we found out, my lord, is when we got the docket subsequent to that, and when we requested the B and C sections of the docket, which was refused, my lord, and we had to set down a formal application that they settled the night before, and then had an absolute, as we've just seen now, volte face, where they said, no, well, we've changed our mind, you can have it. So now, for the second time, the state has changed their mind, my lord, and it does impact with respect on the trial going forward. Because we're entitled to another case we have to meet. So we're finding out as we go along about it. So it may be resolved, that point may now be resolved, my lord, in that she's no longer a state witness,
Yes.
which would then mean that the evidential burden or the evidence that we thought that we have to meet doesn't exist anymore because that statement doesn't say. So it is a factor that ought to be taken into account. That may very well have had a material effect on the bail court at the time, my lord, thinking it was a strong case because the allegation was made. The accused PA, his most trusted employee, now turned against him and given us a statement which was false.
But Mr. Otis, that horse has bolted. Your client got bail.
I accept it.
Your client got bail. He is here on bail. So that issue is neither here nor there.
Accepted, my
What
lord.
you now have is a situation where you may speak to the person because obviously she's no longer a state witness, They have now disavowed her as a state witness. You may now speak to her. You're at liberty to speak to her. Consult with her. If she wants you as a legal representative, you may represent her during the trial. So you have all that. And I'm saying you have no cause of complaint anymore when it comes to this
Yes, my
witness.
lord, but let me just explain why it becomes an illustration of the conduct here, my lord.
Oh, okay.
Okay, so I accept what your lordship says. I thank you, and I ask your lordship to merely take note that you only found out now,
Oh, yes.
on 3rd of November, that that's the case. Now, if we go back to section 27, my lord, and I know it's beyond what your lordship said, but my learned friend has not answered your lordship, because section 34 charges have section 27 as a prerequisite. And the prerequisite, the two things they have to do, my lord, is get a certification, and even prior to the certification, approach the accused for an explanation. Now, your lordship has asked him 3 times. These are objective facts. Did they happen? He wants time to file an answer. But he should be in a position, with my lord, as prerequisites to state yes or no. They were approached for explanations, because I'm telling your lordship as a fact, as an officer of the court, the answer is no. So the charges can't stand, but he hasn't answered your lordship yet. It's similar to the situation I had with Ms. Chilotto. So that it hasn't happened, and then, my lord, in order to be able to charge a person in terms of section 34, you have to be in a position to furnish that certificate up front. Not say, well, I'll find it, or we'll go and approach them. Now, as he told your lordship, I made a note, he says, well, we'll still go see them, and your lordship said, no, this was meant to have been done in advance. It hasn't happened, my lord. So it's improperly before this court, and it ought not to be there, but he hasn't answered your lordship. And with respect, my lord, I'd like him to answer through your lordship whether he contends that my client, accused number 13, I beg your pardon, has been approached and asked for an explanation, because I'm putting on record that it hasn't happened, my lord. Thank you, my lord.
But I assume that it also did not happen with regard to accused number 16. Otherwise, they would not file that notice.
I
Yeah,
draw
but-
the same assumption, my lord.
Yeah.
That's my answer to that.
All right.
May I?
Oh, let's
confirm what your lordship just said. Accused number 61 never. And I just want to confirm also, your lordship, a letter was sent to the nation on the 18th of October already, requesting the same. So it's not a-
requesting the authorization.
Yes.
And no response was forthcoming.
No
Or
response. Thank you, ma'am.
thank you. Mr. Donation, did you receive this letter of the 18th?
My lord, I'm not 100% sure. There's a huge number of documents sent to us on a weekly basis. But if I find it, I apologize to Mr. Kramer. But the authorization, to answer to Mr. Harris's problem, the authorization has been given. The request for, or the opportunity for a explanation has not been asked to answer those 2 questions.
But you are aware they must coexist.
Yes,
Can't have the one without the other
yes,
before you institute the proceedings.
yes.
Good.
Sorry, Lord.
Yes. Yeah.
Devon,
Good.
I'm instructed a similar situation exists. He was also not approached for an explanation. And then, the Lord, in respect of the applications relating to the question of the fairness of the trial, my instructions from accused number 11 are that he also gave evidence before the Zondo Commission.
Yeah, I think I
But
saw that
await
in his note. Huh?
Mr. Zulu.
Mr. Zulu, yeah.
But I await final instructions as to whether we are going to bring such an application. If those instructions are that we should bring an application, then obviously we will abide by the timelines that are set.
Okay.
That's what it is.
Thank you. Or maybe you might, as well as a precautionary measure, be part of the group
Yes.
dealing with those timelines, with the roadmap.
The Lord, whilst I'm on my feet, may I believe that the court hand up accused number 11's reply to the 212. I don't know if the state has been furnished with it, but one has not found its way to the court's
In the
file.
court file, okay.
And my instructing attorney had difficulties transmitting it, I understand.
Yes, okay, it's fine, no problem.
May I similarly hand up the accused 3, 4, 13, but they have been served. I understand there were problems with the emails, and I need to record as a fact, my lord, that the accused 3 and 4, though having changed the attorneys, stand by that which was filed by Fluxman, my lord. So the accused are present and the new attorney are not confirmed that. But as a precautionary measure, my lord, may I hand up 3, 4, and 13's responses.
Yes, I now return to my previous question about the trial readiness, Mr. Donation. Can you assist me there? Or should we postpone the matter provisionally, because I think it was one of the accused who objected the last time that they find it expensive to come to court every now and then and not convenient. I don't know what you suggest now that we have clearly accused 1, 3, 4, 13, 11 who might file objections that must be argued before the trial date. Now I'm asking, bar that issue. Otherwise, other than that, and right, Ms. Cholota has also now arisen. Other than that, is the matter trial ready? And from your perspective?
It is. My Lord, and if I may just very briefly answer to the allegation by my colleague, and I call it an allegation, or the suggestion of so-called dishonesty by the state, I reject it with the contempt it deserves. There were no dishonesty whatsoever. She was a witness at that stage, and she was a witness until quite recently. She promised her cooperation. When push came to shove, she did not want to cooperate, very clearly and bluntly. So that changed the whole situation. And may I say that was quite recent. Apart from the Charlotta issue, the matter is trial ready. We can proceed, and the state is ready to proceed.
All right. It seems to me then that except for the issues raised by accused 1, 3, 4, 11 and 13, there are no other issues by any other accused with regard to preliminary issues. None. Okay. And obviously there's no trial date arranged yet.
No, ma'am.
Sorry, Lord.
Yes.
We call upon the state to give us some idea of the time frame in order to get the witness/accused from the USA here, because presumably that accused will then have to be acquainted with the docket, instruct legal representatives, etc. And as my Lord has indicated, the accused do suffer prejudice having to come here each time. And should that individual in the USA not be at all cooperative, technically it could take months.
But I think he said they are prepared to continue without her.
As well, Jesus.
That's what. Did I understand
At
correctly?
what stage, my Lord, do they give up?
I don't know, but look, if they say, if the witness is not here by the first day of the trial or arrested and given all the necessary documents, they will continue without her. Then we will continue without her. It does not mean that she has to be charged with these accused. She can be charged separately. if needs be, if they decide to charge her. But Mr. Donation has indicated their preference is to add as a co-accused in this matter. So I suggest that we firstly arrange a trial date, or alternatively we arrange a provisional date and give Mr. Donation time to have the witness arrested and follow all the extradition proceedings if necessary. She might just be a cooperative accused person and fly back to South Africa voluntarily. But more importantly, we then get dates by which you will file your respective applications, dates by which the state will have to answer, and you reply if necessary, and then obviously the matter can be set down on the roll so that those matters be adjudicated upon by either the trial judge or any other judge whom I allocate the matter to. So I think it's best then that I adjourn so that you apply your minds to the issue, and that counsel for accused 1, 3, 4, 11, 13 give me proposed dates as a roadmap, failing which then I will have to determine those dates myself. I will now. How much time do you need? Well, to make all those arrangements, seeing that there's a whole host of you here.
I would suggest 15 minutes.
15. Mr. Donation, is that okay?
As a pleaser.
Right. The court will adjourn 15 minutes.
On your rising court.
The outcome is going to be what's going to be provided by Mr. Mason, obviously.
The outcome pertaining to? Look,
Section 27.
yeah, but that is something that is governed ex lege. It's
Yes.
subjective. If it's not there, they can't institute any proceedings against
They
the
didn't
client.
comply, they didn't comply, you should, so
Yes.
you have to withdraw.
Yeah.
Thank you.
And well, the request for further particulars is also something that is governed by the Criminal Procedure Act. They have indicated that they will indeed comply with the provisions of Section 87.
Thank you, Lord.
Good. All right. The matter against the accused is postponed to the 21st of February 2022. All the natural persons are warned to be in this court again at 9 a.m. the morning of the 21st of February. With regard to the objections, the applicants to file their notices of motion on the 19th of November 2020, the state and to answer by the 7th of December, and the applicants to reply on the 15th of December 2021. Thank you. Is that it? Anything else? Good. Thank you. Court adjourns.
One, two, 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 two. 1 2 2 2 2 2. Happy, sharp, sharp.